police officers expecting incentives to criminalize purely civil transactions, it is commonplace. It is all over the place. Now, this I call bribery and then corruption, which really occur at the police station almost on a daily basis. Some police officers think that every docket that comes to them is business, from which some money must be made. And so the person is arrested and they begin to give attitude to the suspect, indicating that if you don't pay, you're not going home. Yes. And sometimes too, the complainant will pay the police to say that go and arrest him, I'll give you this percentage of the amount. And when the money is promised that way, the police become overzealous. Overzealous prosecution means that the police think that they are the victims of the crime because they have something to benefit. And this is really serious because it involves human rights. Now, when a police officer takes money, they begin to do a whole lot of things. One of them is that they embellish the facts of the case to make it look as if this person is the worst criminal ever. So a matter that is so simple, that has no incriminating, aspects, the police will borrow a lot of jargons. I remember I did a case recently, in fact, I'm still doing it, in a district court. The case is that the complainant and my client, who is the accused person, fought at the farm over a piece of land.
Welcome. Good afternoon. And we bring you a second installment of our legal clinic where we sought to empower you on what you ought to know when you come face to face with the police or law enforcement. So today we continue and we title today's 10 things police must not do to suspects. 10 things they must not do to suspects. And joining us once again is Daniel Krang, who is lawyer and author, and he works from the Adum Legal Consult, which is in Sunyani. And we are thankful to also be joined by Dr. Justice Shremsai, who is a lawyer and teaches the law as well at the Gimpa Law School. Gentlemen, Merry Christmas. Thank you so much for sacrificing your afternoon to join us to educate our people on the law.
Yeah, good afternoon, my very good friend.
Thank you very much, Samson,
for your kind work that you are doing for our beloved country.
Thank you very much. Now, we will start with you, Justice. There's a matter that is alive, it's live, and on the back of which you have sought to educate the public through a very, down-to-earth article that many people have enjoyed on, online. We want to bring it, to the studio here and for the benefit of our audience. Number one, if I'm arrested, if I am restricted or I have been detained by the police, what is it that they cannot do to me or must not do to me according to law?
Thank you very much. Let me go straight to the point to try and answer the question. A bit of some background. Our policing culture has not improved over the decades. It didn't improve when we gained independence. It didn't improve when we finally, came under the 1992 Constitution. And as someone who has trained police officers, police prosecutors, and investigators, I have come very closely to the culture of policing in this country, and it appears that regardless of what we try to do to improve the policing culture, the police are unwilling or unable to change. So, for example, you have taken police investigators through training, and at the end of the training, they tell you, Doc, but if we should go by what you are saying, then we can't get anybody. Basically saying that if we go by the principles of law, which places standards and procedures on them, then they are unable to arrest anyone. But that cannot be true. It is a culture which has not changed. So, like my colleague Daniel was saying, policemen have found it necessary to, they sometimes think of their job as a business, extorting money from both the complainant and the suspect. And that is more, it brings them more motivation than what the law says they should do. So if you arrest someone, I don't think that there's a policeman in this country who doesn't know that you can no longer, take someone's mobile phone and then open it and start searching. Because about 4 or 5 years ago, there was a decision by the courts of Ghana that you can no longer just get someone, pick the person's phone and start searching. The same way, you cannot just walk into someone's home as a police official and then start asking the person to open his home to you to conduct a search. Yet we see police officers doing this every day. And so, for example, one, when you arrest someone, you cannot, as a police officer, just take the person's electronic device, be it computer, mobile phone, or any other electronic device, and then ask the person, hey, give me your password and let me go through. You can no longer do that. You need specific court warrant indicating that you have to search this. And the courts in those decisions have explained that you can, as a police officer, take hold of the gadget. But once you get hold of the gadget, there is no power vested in you to open it. You can take the gadget then to a court and ask for an order to open the gadget and go through. So what I'm saying is that if you're a citizen and you are watching this program, know very well that no police official has any power or authority whatsoever to pick your gadget from you and start searching through for whatever evidence they want.
What happens frequently that we get told is that once your gadget or your phone is seized, you are commanded to, as it were, give them access to the content. And if you don't, then they begin to act antagonistically towards you.
Yes, so that is exactly the point. I don't know anyone who will be willing, without compulsion, to give another person access to their mobile phone. So for me, anytime I see or I hear of a police officer claiming that the person gave him access to the phone, to open the phone or gave him the password, I know automatically, and I believe all judges know, that that password was not procured voluntarily. And one of the key, Samson and Daniel, one of the key things that guides police pre-court investigation when it comes to gathering of evidence is either the law allows you or the person voluntarily gives you the access.
Right.
And voluntary doesn't mean that when you threaten me, because most of the time when these police guys are coming to arrest you, they are not friendly to start with. So the mere fact that they are coming at you with guns and batons and whatever they have is enough compulsion to let you, even without any other explanation, it's enough compulsion to let you give them the access to the gadget. And let's not forget, a policeman cannot arrest you without telling you certain things. So that leads me to the second thing that a policeman cannot do. A policeman, when he's arresting and wants to gather any form of evidence, must first of all inform you that he's arresting you, you are under investigation for so and so crime, And most importantly, that you have the right to remain silent and not to give him access to anything. And that it is only when you feel comfortable to give him access or to tell him anything that you can tell him something. And when you say anything, that thing that you said and any access that you give them, whatever they gather, may be used as evidence against you. The police official ought to tell you this first before taking any step. So in other jurisdictions, it is in the genes of every police official. You won't find a police officer coming to arrest you without telling you all these things. It is because the law understands and knows that the public are not aware of this. So every police official has a duty, unless there is a circumstance which does not allow for that. But every police officer has a duty to inform you of what I've just said. And importantly, that you have the right to counsel. So second thing that the police officer cannot do is to start asking you questions when your lawyer is not around. Because the training manual of every police officer is that you inform the person of his right to counsel. When he accepts that, well, I want to waive my right to counsel, that waiver cannot be by word of mouth. The law says the police officer should what? Call an independent witness and let the person sign that he's giving a waiver. So if you look at the police, form, the form that form that they use, statement form.
Yes.
When they are writing, first of all, there must be a statement that you, the suspect or the accused person, you have been duly informed of your right to remain silent, and that your refusal or your decision to speak is voluntary, and that whatever you say will be used as evidence. What the police often don't do is that they write these things quietly without telling the accused person anything. And then when they write it on the paper, they compel you to sign. And then you sign, and then they ask you, sometimes, even though the person is literate, probably sometimes even more literate than the police will tell you not to write, they will write for you. And they will ask you questions, and then they start writing. As to what they are writing, you may not be sure of what they are writing. At the end of the day,
for many people in an illiterate population, it is the police that actually will write that statement for them.
Exactly, which itself is problematic. If you are an illiterate person and you confront a police situation, what I will advise you to do is to remain silent. Make sure you get a lawyer of your choice. And if you cannot have access to a lawyer of your choice, I will still advise you to remain silent until you appear before a judge. Then if you have anything to say, then you can say, because the judge is a guarantee that whatever you are saying it voluntarily.
And I need you to explain that, because that comes up on the matter that I subsequently will refer to you and ask your view about it. You say that they are supposed to inform you first of your right to a lawyer of your choice.
Precisely.
And then you need to have access to that lawyer to be able to give your statement in the manner that you want it. But you are saying, in addition, that you actually have a right not to say anything when they say they need you to put something on paper.
Yes, you have the right to say, I don't have anything to say at this point, or I have refused to say anything. And that is your right. No police officer can compel you to say anything, and they have no such power. So anytime a police officer puts a gun to your head and is trying to compel you, try as much as possible to not say anything. But the reality is that not everyone has the courage to resist or has the instinct to avoid being harmed. But at the end of the day, the law court is going to look at whether there is evidence that you gave your statement voluntarily. So now this turns me to the other aspect of the discussion. There's a concept in criminal justice which ties police behavior to the court's jurisprudence. So police people, generally, the research shows that police people often behave in line with what they think the court will do. If the police, for example, if the police officer is aware that a court will reject evidence which was obtained illegally, the police are likely to follow the rules and procedures of gathering evidence. But if the police officer is confident that regardless of how I obtain the evidence, the court is going to accept it and use it in prosecution, then that police officer is likely to disregard every rule and every procedure that is required of them. So take, for example, in the United States, and I'm sure we often see these things in films and even sometimes in live events. Hardly would you see a police officer in an advanced country arresting someone without telling the person of his right to counsel and that he has the right to remain silent.
That's correct.
Because over there, they know very well that if you gather any evidence or any statement the person gives under those circumstances would not be accepted by a court of law. What we seem to have in our jurisdiction is that it appears that the courts accept anything that comes and let it go in. And it's a very old common law position, but even in England, that position doesn't hold anymore. So maybe perhaps it's time for us to also begin to make a very humble call on our courts to try as much as possible to begin to reject this, because you see, we are having police brutality at a level which is apparently above every African country. The last time I saw police brutality research, Ghana was leading. Ghana was leading in terms of police brutality, even in Africa. So it tells you that we are actually below the standard, far below the standard. And it's not far-fetched. I mean, we see it every day. If we are lucky, sometimes we get these things on camera and someone just takes videos and we see it and we all begin to behave like it's a new and a shocking debate. I can tell you, it is, as far as the police are concerned, that is their standard procedure.
Right.
And so, yeah, Samson, I'm listening.
Elsewhere, the police actually have body cameras. So the things that they engage with the suspects are recorded so that they themselves are recording the events that could be used against them.
Exactly. So it tells you that in other jurisdictions, they are taking these matters more seriously than we do here.
Right.
Here, even when a bystander is videoing, the police actually have the guts to actually approach the person, beat him up, destroy the camera because the person is videoing the interaction.
I will return to you. I will return to you, Dr. Justice Ramsay, on that point. And please remember, we are dealing with 10 things that the police must not do to you as a suspect. And that is the pre-trial processes before they even take you to court. And Dr. Justice Ramsay has made it emphatically clear. And remember that this is someone who has the opportunity and privilege, because of his expertise, to also train police prosecutors. And these are some of the things he teaches them not to do. Not because they are his opinion, but because they are the law. Number one, he says, what is becoming very common is that your phone is taken, or a gadget is taken from you, your laptop, and then immediately you are asked to give them access to it. This is not the first time you'll be saying this on this show. But today, on a special edition for your Christmas, we want you to remember some of these very important things. The police do not have the right to access your gadget. If they ask you for your password, you have every right and title not to give it. They can only access your gadget or your phone by an order from the court. So they can seize your phone, they can seize your gadget, but they cannot break into it or access it until they have taken you and that article to court and ask and empowered to do so. And I remember, as Justice referred to about 4 years ago, he did a case in the Human Rights Court, and the court was very emphatic that police cannot do this. He says, number two, remember and never allow it to happen to you. Because when you are under a certain, strain, and a police officer is breathing heavy on you, you don't have your mental faculties correct. Sometimes the pressure is so much, you're already afraid of being at a police station. And so you can give statements that will be self-incriminating or you can say things that will be used against you. They must not force you to make a statement. They don't have that right. They are expected by law in Article 14 of the Constitution to tell you in a language that you understand, that you have a right to a lawyer of your choice. Very important. And that anything that you will say to them could be used against you in a court of law. Number 3, he says, get access to your lawyer. If you want to waive it, you have a right to waive it and say, let's go on with the process. I can't afford a lawyer or I don't have a lawyer. But number 3, he says you can actually decide not to give any statement. And it is your right to say, I will not give a statement at this point. They will process you, take you to court. Maybe by the time they are taking you to court, you have calmed down, everybody has calmed down, you have your mental faculties, right, you are relaxed, and you can write your statement in a way that is acceptable. I hope I have done some work precise to summarizing. Now, Daniel Krang joins us again, and remember that he has spoken to us about unlawful use of force and police brutalities in arrest, and Justice just mentioned a bit of that. He spoke about manhandling and torture of criminal suspects upon arrest, disallowing suspects from reaching their families. They can't do that to you. It's absolutely unlawful, unconstitutional. Seeking assistance. When you are arrested, they must allow you to have assistance. Making phone calls, they must allow you. Accessing medical care, etc., they must allow you. He spoke about they sometimes writing incriminating statements for you, the suspect. They are writing it for you because maybe you can't write and you are dictating to them. If it is over, let them read it over to you and be sure that everything there is what you put there. He spoke about extortion of confession statements from the accused, advising suspects against engaging the services of a lawyer, embellishment of complainant's case, criminalizing purely civil transactions or wrongs. Induce guilty pleas, that's when you get to the court. So, Daniel, I'm trying to go back to the first engagement and to refresh your memory.
That's all right, yes.
And to now bring you on.
All right.
So let's begin. What's 2, 3 things do you want to focus on to educate our audiences today about?
Thank you very much, Samson. A very Merry Christmas to our viewers and listeners, every part of the world that they are. Now, let me begin by mentioning that the first I will say is unnecessary handcuffing. Unnecessary handcuffing. Handcuff is a very important instrument that the police use in their work. But let me say also that it is not any time that there is an arrest that the handcuff must be used. What I see often, and what often happens in Ghana, is that the handcuff is used to embarrass criminal suspects. When a police officer arrests a person who is not a danger or a threat, or who doesn't seem to be a flight risk, I mean, you go to arrest a very noble person, maybe in his own car, he says, well, let's go. If it is not a felony that the person has committed, and it is some misdemeanor or a light offense, a very less offense, you don't handcuff this person and drag him along the street just to embarrass him. Sometimes the police do this when they have some motivation to do so, that they want to teach you a lesson by handcuffing you from your shop and dragging you on the streets to the police station just to embarrass you. So the advice here is that when a police officer is going to arrest, it is not every time that the handcuff must be used. When the person will not run away, then you can lead him to the police station. So that's the first I will say. And the second I will say is that
Okay, Daniel's connection is freezing, but I suspect it may have normalized. Daniel, if you are stable now, let's bring you back to the second point. That will make it the fifth, thing that you are being told this afternoon. We are talking about 10 things the police must not do. Yes, Daniel, the second point.
All right, so the second point is that the police cannot arrest an innocent person just to procure the appearance of a criminal suspect. So that when you are looking for a mother as a suspect, you arrest the son. It is wrong. When you are looking for a father and the father is not available, you arrest the wife. It is wrong. When you are looking for an employer to arrest, you go, he's not there, you arrest an employee. It is wrong. So, criminal law is a personalized law. It is a law that deals with a person who has violated it and not their relatives. So you cannot arrest any third party when you are looking for a criminal suspect. That is very important. Now, the third I will say is that when a police officer arrests you, he cannot keep you in custody beyond 48 hours. And I often see and hear that this very principle of law is violated almost every time in our police stations. And what they do often is that if they want to teach you a lesson, they will pick you up on Friday and tell you that it is weekend. So the 48 hours does not start to run. Let me say that the 48 hours also starts or it runs during weekends. When you arrest a person, you must make sure that you do not unnecessarily detain the person. But when you think that detention is important, you make sure you don't detain them beyond 48 hours. This is also very crucial. And another important thing I'll mention is that when a complainant makes a complaint to the police, they cannot dictate the pace for the police. A complainant cannot tell the police what to do to the suspect. Sometimes the complainant tells the police to beat up the suspect or to deny the suspect bail. So that when a lawyer goes to the police station to secure bail for his client, he is told that we are trying to convince the complainant to understand and to agree that we grant bail, and he is not agreeing. This one is very unfortunate. A criminal, a complainant cannot tell the police not to grant bail or to dictate the bail conditions or to tell them that they should deny bail at all. That one is just not right. So they cannot do that.
All right.
Now, I would add this, that when a police officer arrests a person and he feels that he must arraign the person before the court, the police is supposed to serve the person with a copy of the charge sheet days ahead of the court time.
You mean not when the person has appeared? You mean not when the person has appeared in court and then with their lawyer, then they give you a copy?
Sometimes they even give it to the person when he's mounting the dock, when he's entering the box. Then they give him. You are a lawyer, you go to see your client and you ask him, do you have a copy of the charge sheet? He says no. Meanwhile, the police have told him that he will go to court about 3 or 4 days before time. So the law is that, and the practice is that, the acceptable practice is that when a police officer feels that an accused person must be arraigned, they must first give the person adequate notice so that the person can prepare. And apart from the notice, or in addition to that, they have to serve the now accused person with every relevant document that they think they will place before the court on arraignment or on the first day. And you are saying
this should happen before you are put before the court?
Before they are brought before the court.
So traditionally, what we know is that this happens from the day you are put in court. And then sometimes it takes a judge to make the order that they should give those things to you.
What happens is that the police are supposed to file the charge sheet. They'll file the charge sheet. You see, when they file the charge sheets, you are already in court, and they hand it to you there. You have no opportunity to read it. Your lawyer has no opportunity to read it. So how do you prepare to meet the case?
But often they ask you. Important. But often after they have taken your statement from you, is it your caution statement, your charge statement, and then they tell you, we'll get back to you. And then perhaps they call you on a Monday and say, sometimes it's really difficult. They call you in the morning and tell you that we need you to appear in this court by 10 a.m. or 11 a.m. And that is when they are filing it.
That's it.
So sometimes they can actually tell the lawyer that we are unable to tell you which court because we are now going to file, and it is when we file that we'll be told which court we are going to appear. You are saying this is not correct?
It is not correct because the accused person must be given information before time. Sometimes they will invite the suspect, come to report yourself on Monday. You get to the police station thinking you're only going to report yourself and come back home, and they tell you that it is court time, we are going to court. You know, I have mentioned here before that criminal prosecution is an enlightened judicial and legal process.
It's not warfare.
It's not a warfare. So, so you don't try to hide anything just to ambush the person and get him in jail. So we have to ensure that we follow due process and make sure that nobody is unnecessarily, jeopardized.
All right.
I'll mention again. Okay. I'll mention again that
you mentioned this one, and you pause for me, so I go to Dr. Justice Ramsay for one important point. Then I think by the time he will be done, then we can open the phone lines. And whilst we continue to talk, we take people's questions.
All right, thank you very much, Samson. There is this which is very commonplace in Ghana. The police arrest you, and they create unnecessary prejudicial publicity of your arrests and the case against you. So when they arrest you, or before they arrest you, they already arrange for media men to come around. So by the time you are arrested, a lot of pictures are taken of you, videos are made of your arrests, and you are already in the public space on social media and everywhere, prejudicial publications and all that. You know, some of these publications work so much on the minds of judges.
But it must be said, Daniel, that for some time now, it must be said, Daniel, that for some time now, at least, since Dr. Dampari took over, you see that they don't show the faces of the suspects. They don't show the face of the suspect. Even if they take a photograph, they don't show the suspect's face, which is professional. Which is standard practice, right?
That is a commendation we can give. But I would like to say that when a person is alleged to have committed a crime, the police would always proceed against the person on one-sided information. That is the information coming from the complainant. Now, you have not heard the side of the accused or the suspect, and the complainant's side of the story is already out there, which is always prejudicial, which is always against the accused person. You know, when you have not got the opportunity to listen to the accused person, you are unable to know which side of the story to believe. But when one side from the complainant gets into the public, it becomes the public view of the case, and that informs discussions, and viewpoints on the case.
All right.
And judges, and jurors all read from the social media, from Facebook and from everywhere. And so when this is done, it tends to prejudice the minds of judges before the case is even brought to them.
Right. Thank you very much. And you have heard Daniel Krang, who is a lawyer and author of legal texts, which we have shown some to you over a period now. He's dealt with almost 6 extra things that police must not do, which includes what you, the complainant, who are taking your matter to the police, must not be seeking to or demanding from the police. Sometimes the complainant and a certain community, they don't understand why somebody should be granted bail. You know, they feel that granting bail means you didn't go police station and so you didn't call your dear chain on and no, the fact that you have reported the person doesn't mean that, you know, they should be put in custody. Right. Okay. So, Dr. Shams, I bring you back here on the matter that I said is live. This matter of Nana Osei Mensah, the 32-year-old, who was part of the Fix the Country group that were preparing for a demonstration in Tamale, and he found himself at the Tamale Central Police Barracks and took a footage. He was making a video of the Central Barracks, and he was arrested, and on the basis that, and charged with offensive conduct conducive to the breach of the peace, on the basis that when he was filming, he labeled the place as dirty and asked the question whether, you know, police officers could have the sound mind and peace to do their work well if they lived in such, you know, dilapidated or in such conditions. What was his crime in doing that? Is it a crime? And there's an aspect of it which triggered, we understood, which triggered your article, which I will come to.
Yeah, Samson, thank you very much. I mean, what you have just recounted, we all got from the police own statement.
Right.
So it is not even something that we are hearing from the other side. According to the police statement which they put before the court, the gentleman was taking a video and made the statement you referred to. And in the mind of the police, that is a crime. Well, it is shocking that the police will first of all find that a disgrace or embarrassment to them. So in this case, the police they are not finding the condition they are living in as a disgrace, but they are finding a description of the condition as what? An embarrassment to the institution. And that is shocking, that you would think that that is a statement which the police officers themselves ought to be concerned about. They should be making those statements, being the ones who live in that condition. They are not denying that they live in those buildings that we saw in the video. They actually live there, and they are saying that the gentleman who is giving them the description of what they are living in and how that can affect their mental health and their behavior in uniform, that person rather is causing the embarrassment. So it is shocking to have that fact actually on record and put before a court. And I don't know how that is anything. And assuming without admitting that it is even false information that the gentleman is even publishing, assuming that the police were living in, one of those East Legon apartments, well furnished, and the gentleman went and made those statements. Even that cannot, I don't see how that is a crime. It is simply a matter of the police coming to the public to disclose that, look, this is where we live. The gentleman is lying that we live here, when in fact we live in cantonment and we are living in this plush apartment. And that's resolved the matter. And that is where I began by saying that we have a certain culture of policing in this country, which is beginning to sound absurd and actually doesn't make sense if you match it with the democratic dispensation which we have chosen to go by. Freedom of speech, the essence of nullifying the criminal libel law and all the things that we have, happily announced to the world that we have cancelled, is the fact that we want people to express themselves, not because we believe that everybody who expresses himself will tell the truth, but we believe that at least a lie is better than what? Silent. So even if you are lying against a public institution, all what the public institution needs to do is to announce, to tell the truth, and not to come and arrest you and prosecute you in a court of law with the hope that you'll be convicted. So it is actually contrary to common sense that the police would actually arraign someone and put those particulars in the fact sheet and say this is a crime that someone has committed. But that aside, we can leave that to the court to determine the merit. So it is a matter of the court finding whether that is right or wrong, whether there's a crime or not. Let's leave that aside.
Right. Now, the crux of that part of the issue for which that we actually sought to have you to help bring that education here is where in their statement they said, investigation caution statement was obtained from the accused. However, at the concluding part of his statement, Oliver Vomawo, who is convener of Fix the Country demonstration, entered the CID office and told the accused to stop any further statement and should not sign the statement already volunteered by him. And accused, following that advice, failed to sign both the caution and charge statement. So, what are these two statements? And what is the problem you find here?
Okay, so whenever a police officer arrests someone, there are two types of statement that the person may give before actually going to court. The first one is what we call the caution, investigative caution statement. Basically, that statement tells you that you, Mr. A, you are being investigated in respect of certain crimes. Do you want to say anything in respect of those crimes? And as usual, the caution or the Miranda right will come. You have the right to remain silent because everything you say or do here will be taken down as evidence and be used against you in court. At the same instant, you have the right to counsel. If you want to say anything, just let us know who your counsel is and we'll call your lawyer to come so that you can say, we'll give you advice first before you speak. So that is investigative caution statement. At that point, you have not been charged yet, but the police are telling you that someone has made this complaint or we are investigating a particular crime and we believe that you are likely to be someone who will be implicated in the crime. So just tell us what you know about it. The statement is important because it gives the police an idea of what to look out for and what not to look out for. So there's no doubt that investigative caution statement is important. Right. Important though that statement may be, it does not override the rights of the accused as Daniel and myself have outlined earlier. So at this point, you cannot, as a police officer, compel the person to give you any statement. The person still has the right to give you a statement either by himself or wait for a lawyer to come before he gives you the statement. And if the person tells you that I won't give you any statement, all you need to write on that form is that the accused person or the suspect says he has no statement to give. You don't have to take statements from him which implicates him or which is related to the offense. So that's the first statement. Then you can actually, the police can take a number of that kind of statements from you before you are being charged. So you can take investigative caution statement 1, caution statement 2, as you may want. And in fact, the accused himself has the right to add up to anything that he has already said, and also has the right to revoke or recant anything he has said earlier. So it is a free-flowing process. Then, after the accused or the suspect has been charged by the police, so the police have to take another type of statement. And that is what we call the charge statement. The charge statement basically says that, well, you have now been charged with this particular offense. You have the right to remain silent and you have the right to counsel. And everything, note that everything you are going to say to us, we will write it down and we will use it against you as evidence in court. Then again, the issue of voluntariness comes in. If you want to, as it were, remain silent, you still have the same right as you had under the caution statement to tell the police that, well, I don't intend to say anything. I will wait when I go to court. I will tell my story to the judge. And again, the accused can tell you that, well, I'm waiting for my lawyer to come. In the absence of my lawyer, I'm unwilling or unable to give you any statement. And the police is bound to accept that and note it down in the form that, look, the accused person is saying that he has nothing to say at this point and that he reserves his statement for court or when his lawyer comes. So if you look at it this way, there is no space in the criminal pre-court proceedings where an accused person is under any compulsion or could be forced to give any kind of statement. He can only give any statement voluntarily. And that's, even when he gives the statement voluntarily, he must give it expressly either in the presence of his lawyer after seeking legal advice, or he must expressly waive the right to counsel. And that waiver is not a question of the accused person telling you by word of mouth. The law is very, very, the law gives directions to the police. So it tells the police that before you take the statement from an accused person or a suspect who doesn't have a lawyer, there are certain things you need to do.
Right.
First of all, one, explain to him his right to counsel. Let him indicate whether he's expecting counsel or he wants to waive it. If he wants to waive it, take it down in writing, let him sign, and let an independent witness. An independent witness is someone who is not under the influence of the police. So it could be some respectable person in the society. But again, what we also find is that some people are career independent witnesses.
Yeah.
They live nearby the police station, and in all criminal matters, you will see that it's the same person who is coming to say he's independent. There's nothing wrong with that being independent, police, but sometimes it appears that the police have had some arrangement with this particular so-called independent witness who is willing and at any time to just endorse anything that the police do. And when you call them to court, they will say basically whatever the police are telling them. And then all courts have made it clear that the person should be someone who is not under the influence or control of the police, police official or the police institution. So if the person's behavior is said that he is someone who is accustomed to always working with the police, the person loses that independence and then becomes...
Let me now announce, for those of you watching, you can see clearly that the phone lines have been activated. So you have the opportunity to call and ask any question regarding when you are arrested, or you have been detained, or you have been restricted by the police, or you are being put before a court of law to be tried, what they can or cannot do to you. And also, we must clearly pose the caveat. We are speaking here because of the things that generally happen. Not the case that these things always happen in all police stations with all police officers. They are very professional officers who will actually assist you properly. If you want to give a statement, they can actually tell you, we think you should get a lawyer first. Don't do it. And you may even insist that you want to go ahead and do it. And they will tell you, please, I'm advising you, it's better to get a lawyer or do this before you actually put something down. And some of them are super professional. But the things that happen too often are the things we are talking about in part 2 of the excesses that we find with the police. Richard, you're calling from Nungwa. After you, we have Justice. Richard, go straight and let's have your question quickly.
Please, my question is...
Richard, go ahead with your question.
Please, my question is, can a police seize your license? Do the police have the right to seize your license?
What license?
Your driving license.
Under what condition?
Maybe you might not park well, and then the police will come around to seize your license for not parking well. Okay,
thank you for your question, Richard from Nungwa. Then Justice, you are calling from Koforidua. What's your question?
I'm calling from Wasekopo.
Okay.
My question is, under what condition, as you have taught us, we know that every crime is bailable, but then sometimes you go to a police station and they, even after the 14 hours, they don't want to give you the bail.
Yeah, so what's the question?
What are my remedies in that instance when I'm denied bail or I'm asked to pay money?
What's the question again?
I said, when you go to more than 14 hours, the family comes around to bail you, and the police are still demanding for money.
Okay.
Or they are going up and down.
All right. Demanding money for bail. Thank you for your question. Let's go to Wanda. Wanda, you are calling from Medina. Let's hear you.
Okay. The question I want to ask is that...
Go ahead, please.
Okay. The question I want to ask is that, assuming police come to your house to arrest you, can you say that they should be going so that maybe you come to the police station under any circumstance?
Okay. Can you ask the police?
Or what are some of the circumstances in which you can say they should be going, you will come or not? Yeah, I want to.
Okay. Thank you. Raymond, I take your question and then we take a pause and then we take some answers. Raymond, you are calling us from Akuse. Let's hear you.
My name is Raymond calling from Akuse Medica. I want to know that you are not supposed to, the police is not supposed to detain you for more than 48 hours. And if they have detained more than 48 hours, what happens? Because we've seen in the case of Oliver, and then it looks like everybody has gone to sleep on that issue. So we have to that. Thank you.
Raymond, say that again.
I'm saying is that if police have detained you for more than 48 hours.
Okay, for more than 48 hours. If they have detained you for more than 48 hours, what can you do?
Yes.
Okay, thank you very much.
We've seen that thing happen when Oliver was arrested. He was detained for more than the 48 hours. And and everybody seems to be sleeping on.
Okay, all right, thank you. So let me begin with Daniel. Daniel, can the police seize your license, your driver's license? Hello, Daniel.
It's a big no. When you are, what we see often is that maybe just as the questioner said, you have wrongly parked somewhere at a no parking space. The police comes to you and says, you haven't parked well, bring your license. This is not done anywhere. If the person has not parked well and he has committed a crime, you arrest him. You don't seize his license. Even sometimes when the license has expired, the police will seize it. But there, let me sign this caution that when your license has expired and it's a criminal offense, then the police may need evidence of that crime. And so they may tell you that.
But you are supposed to carry your license with you and produce it when it is demanded. So, what is the purpose? If you are supposed to carry it along with you and produce it when it is demanded, what's the purpose? If it is not for the police to seize it when they have an issue with you.
No, they cannot seize it when they have an issue. But I'm trying to distinguish the issues. If your license has expired, they may tell you that, listen, we are not giving the license to you because it has expired and that we need it as evidence to prosecute you.
Okay.
But apart from this, if you have maybe overloaded as a driver, it has nothing to do with your license. If you have wrongfully parked somewhere, it has nothing to do with your license. And so the license shouldn't be, a matter of arrest.
All right. So in case of your vehicle, they are supposed to detain your vehicle at the nearest police station so that you can show up. The reason they ask for your license is because in Ghana, where they would have taken your address and they'll be able to trace you to come, that doesn't happen. So they actually will take your license, which will sort of compel you to show up, but they don't have the right to do so. Right.
That is wrong.
Okay.
Where the license has no issue, the police cannot seize it.
All right. All right. So we are running out of time. So let's go to the next issue. Can the police demand money for bail?
That is no. We don't pay for bail. Bail is not for sale in Ghana. If I should repeat, bail at the police station is not for sale. So when you go to the police station and somebody asks you to pay money, you tell the person you need a receipt for that, a public receipt, so that when you pay, they issue receipt. If they cannot issue receipt, you don't give them money for that.
But when you go to the police station, the writings are there. If I go to the headquarters here in Accra, they write it all over the place. Don't pay money for bail. Bail is not for in terms of money. So if you go and pay money to some officer, it is your own thing, isn't it?
Yes, but you see, sometimes the reason people pay for bail is that the police may not ask you for it, but the attitude they will give you shows that you're going to sleep here tonight. And so you have to bargain your rights. You have to just suggest something to them. So the law is that bail is not for.
Or they may actually suggest to you. I know of a couple of situations where they have suggested to the clients that they should do something quickly, or otherwise the person will stay there. Wanda, so Richard and Justice, their questions have been answered. Let's go to Dr. Justice Ramsay now. Wanda was asking, when can a suspect ask police to allow them to attend to the police rather than they arresting and handcuffing the person to the police station? And what can a suspect do if you are detained beyond 48 hours? We don't have justice. Daniel, what would you say to these two other questions?
Yes, let me say that when when you have committed a crime or you are alleged to have committed a crime, we have various kinds of criminal offenses in Ghana. We have categorized them in terms of their gravity or seriousness. We have a felony, we have misdemeanor, all those classifications are there. When you have committed a lesser offense, like assault, you have beaten somebody, or that you have fought in the public place or what, when the police come to you, to your house and say that somebody has reported that last night you slapped him, this is a common case of assault. When you are bathing, when you are eating, when you are in the church, you can tell them, listen, I am going to report myself after church, so please go, I'll come. But certainly not when you are alleged to have committed certain criminal offenses like stealing, which is a felony.
But the police have the discretion to allow you to come by yourself. They have a right to arrest you if they decide that arrest is what they will do.
Yes.
All right.
They have that discretion.
Okay. Right. What can a suspect do if they are detained beyond 48 hours?
That if the police detains you beyond 48 hours, you can sue them for violating your right. The 48-hour rule is a right that the Constitution confers on every criminal suspect.
Right.
So when it is violated, you have the right to go to court for them to pay compensation to you for violating.
But we understand that the Supreme Court has now said that the Saturday and Sunday and holidays, which they use as the pretext to hold you over for more than 48 hours, the Supreme Court has now said that if someone is arrested and the 48 hours is in jeopardy, they should take you to court even on Saturday, Sunday, or a holiday. Okay, the practicality of that matter is in question. So now we know that.
Under the...
Yes, go ahead. Oh, your line is freezing. And we know also that sometimes when it's a misdemeanor, very small issues, there's no actually things about you are being a flight risk and the rest of them. Sometimes they actually call you on phone and they invite you to come. It's just that some people are too difficult. They just don't want to listen. But you have a right. If they invite you, you can decline the invitation so that they arrest you. Some people prefer an arrest. This is where we will end it for today. And we'll say thank you very much to our guest. Daniel Cran is a lawyer with Adum Consult. He's also an author of legal texts, particularly he writes on criminal law. Dr. Justice Shramsai is also a lawyer and teaches at the Gimpa Law Faculty. I'm Samson Lardy Anyenini. This has been your Christmas edition of the law. This is your legal light. It is your help law. I hope we have helped you to assist yourself when you find yourself in difficulty with the police. Have a good day and enjoy your Christmas.